Buzz out to the jail and to the prosecutor's office. And, see, 1 o'clock, we're supposed to have the JD too. I don't know why one of those on there.
Recording in progress.
Where's that? Yeah, I got it now. And then all right, everyone. Are you Donald Costetter?
Yes, sir.
All right. The case number 21 CR 170, State of Ohio versus Donald Gale Costetter. Mr. Costetter is appearing from the jail by Zoom. His attorney is Jacob Wagner. He's appearing by Zoom. Also, Mr. King on behalf of the state. Now, Mr. Wagner, do you and your client both agree to his appearance before the court remotely by Zoom rather than in person?
I do. Donnie, this is what I talked about the Zoom hearing about. Are you still fine with that? Yes, sir.
All right. Mr. Costetter is charged with escape and theft, and I think the matter is set for trial either later this month or early next month. And I have been presented with a plea of guilty for Mr. Costetter, which says that you're going to withdraw your not guilty plead guilty to count 1. And I'll hold this up to you, and you recognize this form that I'm showing you on the camera as your name, case number on it, says plea of guilty there.
Yes, sir.
All right, on page 3 of this agreement, there are signature lines, and not quite halfway down, there's a sentence that reads, I enter this plea voluntarily. Below that, there's a line for signature defendant. It appears the signature is Donnie Costetter. I'll hold that up to the camera, and is that your signature I'm pointing at right below that statement?
Yes, sir.
All right. When did you sign this agreement, Mr. Hostetter?
Friday.
All right. Was there at the jail?
Yes, ma'am. Yes, sir.
Not the problem. And did Mr. Wagner go over with you and explain it to you before you signed it? You understood it was an agreement to plead guilty, which means there's not going to be a trial. The next step would be a sentencing hearing?
Yes, sir.
Do you feel you had enough time to fully consider this matter before making this decision?
Yes, sir.
You haven't changed your mind over the weekend?
No, sir.
All right. Now the agreement, and you're entering into the agreement voluntarily.
Yes, sir.
Right now, the agreement states that you're going to withdraw your not guilty plea, plead guilty to count one, escape under 2921.34A1 of the Ohio Revised Code. That's a third-degree felony. Further states that you understand that the maximum possible prison term for that could be 36 months. The minimum would be 9, and there's certain levels in between those two ranges. And there's a fine available of up to $10,000. You understand that?
Yes, sir.
And are you facing any felony charges anywhere else, Mr. Hostetter?
No, sir.
Now, I know you're in prison currently, serving a sentence, is that correct?
Yes, sir.
All right. And if you are convicted of this offense and sentenced to prison, that term could be ordered to be served consecutively to the term you're serving now, which means on top of it, so it would make your stay in the prison long. You understand that?
Yes, sir.
And are you currently on community control, probation, parole, or post-release control for a felony?
No, sir.
Now, under the law, Mr. Hostetter, if you are convicted of this offense and sentenced to prison, once you complete the prison term imposed by the judge, then upon completion of that, the Adult Parole Authority will place you under what's called post-release control for a mandatory period of 1 year. And that means that you'll be supervised under terms set by the parole authority. The judge has nothing to do with that. If they determine that you have failed to comply with those conditions during that 1 year period, then they can return you to prison, even though you served the entire term set by the judge, or an additional period of up to, in this case, 6 months for one or more violations. However, if you are convicted of a new felony, then in addition to whatever sentence the judge in the new case could impose upon you, that judge could also sentence you for committing that crime while under post-release control, in this case, to an additional period of 1 year. And that would have to be served consecutively to the sentence in the new case. You understand that?
Yes, sir.
Now, under the law, this is not a mandatory prison offense, so I could impose what's called community control, which is more commonly known as probation, which means that instead of going to prison, you'd be put under the supervision of a probation officer for a period of up to 5 years under terms set by this court. After that was completed, then you would be released. Now, if during that period of time they felt that you had not complied, then they would file a notice of that with the court in writing, serve a copy on you, and then you would be entitled to have a hearing and be represented by an attorney. If the outcome of that hearing was that you had failed to comply, then at that time the court would revoke your community control and then sentence you to prison for 36 months and fine you $10,000. Do you understand that?
Yes, sir.
All right, now, the charge in count 1 alleges that on or about September 10, 2021, in Hyde County, Ohio, you did, knowing you were under detention, other than a supervised release detention, or being reckless in that regard, did purposely break or attempt to break the detention, or purposely fail to return to detention, either following temporary leave granted for a specific purpose or limited period, or at the time required to serve a sentence in intermittent confinement, and you were being held in connection to a felony of 4th degree to wit, failure to register a change of address as a registered sex offender, violation of ORC 2950.05F1, the Ohio Revised Code, Hyde County Police Court, case number 21 CR 01003, in violation of section 2921.34A1. So that's the charge of escape, the 3rd degree felony, which carries a possible prison term between 9 to 36 months in the increment provided by law of fine of $10,000. Mr. Hostetter, you understand what it is you're charged with in that count, what the state says you did, when, where, and how they allege that you did that act?
Yes, sir.
You understand the possible penalties for that offense?
Yes, sir.
Now, have you discussed the nature of the charge, the evidence in the case, possible legal issues in the case, possible defenses you might try to raise at the trial, and the possible outcomes of that trial with your attorney?
Yes, sir.
And are you satisfied with his advice and confidence in this matter?
Yes, sir.
Now, are you under the influence of any types of drugs or alcohol at this time?
No, sir.
Are you taking any prescription drugs?
My mental medication.
Okay.
That's like meds.
All right.
You know,
But do they interfere with your ability to understand what you are hearing or reading or observing?
no.
Or interfere with your ability to accurately answer appropriately answer a question?
No, they don't.
Okay. Now, have any threats been made to make you plead guilty here today?
No.
Now, there are about 3+ lines on page 2 that are underlined and printed in bold, which are the key sections of your plea agreement. So I'll read that to you as follows. Defendant shall enter plea guilty to count 1. State will dismiss count 2. State and defense jointly recommend 12 months incarceration, consecutive to the term of incarceration defendant is currently serving in case number 20 CR 103. Defendant agrees to make full restitution. Is that your understanding of the agreement?
Yes, sir.
Has anyone promised you anything other than that to get you to plead guilty here today?
Yes, sir.
Now, under the law, the judge is the one who imposes the sentence, not the parties. So even though there's an agreement as to what the sentence ought to be between you and the state, if you plead guilty, I'm not obligated to follow that recommendation. So once I've heard all of the information submitted, I decide that's not the correct sentence under the facts of the law, I could impose a sentence of anywhere between 9 and 36 months as permitted by the statute. I could also fine you $10,000. You understand that?
Yes, sir.
And what is the restitution number, Mr. King?
It is $20.45 to the Highland County Sheriff's Office.
All right.
If I may, Your Honor,
Yes.
Donnie asked for the Crocs and the stuff you were wearing, okay, bud?
Oh, okay.
Okay. All right. Now, you have certain constitutional rights you must understand before I can accept your plea of guilty. First of all, you have the right to have an attorney. Mr. Wagner was appointed by the court to represent you, Mr. Hossetter. Now, his appointment wasn't simply to work the case out, but to provide any defense that could be available to you under the law that you would like him to provide. So if you decide that you do not want to enter this plea today, he'll continue to defend you, including going to trial, if that's what you want. Do you understand that?
Yes, sir.
Right now, under the Constitution, Mr. Hossetter, you have a right to have a jury trial in this matter, in which 12 people would be selected from a group of citizens that live in this county that are summoned for jury duty on your trial day. After they are selected, the evidence will be presented and they'd be instructed on the law. And then that jury would have to decide whether or not the state proves your guilt or proves beyond reasonable doubt on the charge. And that verdict would have to be unanimous, meaning all 12 of them would have to agree. Now, if you didn't want to have a jury trial, but you didn't want to plead guilty, you can waive in writing that in this context, waive means to give up your right to have an attorney. Your right to have a jury trial. And then, in that situation, the judge would be the one who would hear the evidence instead of the jury, and the judge would be the one who would apply the law, and the judge would be the one who would decide whether or not the state proved your guilt by proof beyond reasonable doubt. Do you understand that?
Yes, sir.
Now, you have the right to confront the witnesses against you in open court and to cross-examine them through your attorney. What that means, Mr. Hossetter, is that the witnesses against you have to come into court in public session and testify in front of you and your attorney and everyone else that was present. And then after the prosecutor was done asking questions, your attorney would ask questions, and that's called cross-examination. And the purpose of that is to bring out evidence that helps your side of the case. Do you understand that?
Yes, sir.
And now, under the Constitution, Mr. Hossetter, you have the right to use the power of this court to compel or force witnesses to come into court to testify for you, just like the state. So if you have witnesses you're not certain are going to come in voluntarily at your request, the court issues a court order, that's called a subpoena. And that forces those people to come to court to be available to testify, even though they don't want to be here, which is the same way the state's witnesses are forced to come into court to testify against you. Do you understand that?
Yes, sir.
And under the Constitution, you have a privilege against self-incrimination, which means you cannot be forced to give evidence in this matter at any time, including trial. So no one can ever make you testify. The prosecutor can't, the judge can't, you decide. If you decide you do not want to testify, the fact that you did not testify cannot be used against you in any way, at any time, by any person in the proceedings. And in fact, no one's even allowed to talk about it, except in one case, and that is if there's a jury trial and you don't testify, then the judge does instruct the jury that because that's your right, they cannot consider it for any purpose. Do you understand that?
Yes, sir.
Under the Constitution, Mr. Hofstadter, you're presumed innocent until proven guilty of this charge by proof beyond reasonable doubt on every essential element of the offense by the prosecuting attorney. So what that means is that the burden of proof is not on you to try to prove you're not guilty simply because you've been accused. In fact, under the law, you don't have to put on any evidence in your own defense. You may, but you're not required to. But whether you do or not, the burden of proof will remain upon the state to prove your guilt on every essential element of the offense charged, which is the highest burden of proof that's known under the law. Do you understand that?
Yes, sir.
All All right, now originally, Mr. Hofstadter, you entered a plea of not guilty, which denied the allegations in the indictment, denied you committed any crime, and it exercised or invoked all the rights I've just described. Now, if you change your plea from not guilty to guilty, guilty plea is opposite of not guilty plea. Guilty plea says I did it, and I committed the crime as charged in the indictment. And that plea waives or gives up all of the rights that I have described for you today, except the right to have an attorney. You always have a right to have your attorney, no matter what your plea is, but with that exception, your plea of guilty waives, gives up your right to a jury or court trial. Waives, gives up your right to confront witnesses against you and to cross-examine them through your attorney. It waives, gives up your right to use the power of the court to compel or force witnesses to be in court to testify for you, just like the state. It waives, gives up your privilege against self-incrimination, because if you say you're guilty, that's what you find you guilty. It waives, gives up your presumption of innocence, because if you say you're guilty, the state's not required to prove that you're guilty. Now, plea of guilty also waives, gives up any right to file an appeal that you think you may have had up until this point in the case. Now, if I should sentence you to the maximum sentence for under the certain circumstances, you could file an appeal. If that would happen to file within 30 days of your sentencing entry being filed. And finally, a plea of guilty subjects you to being sentenced immediately by the court, which is most likely what will happen here today if you plead guilty. Now, do you understand all of that?
Yes, sir.
And are you a U.S. citizen, Mr. Hofstadter?
Yes, sir.
Right, now, do you have any questions about the charge and possible penalties?
No, sir.
Do you understand them?
Yes, sir.
Do you have any questions about the plea agreement?
No, sir.
Do you understand it?
Yes, sir.
And again, you understand the recommendation on sentencing is not binding on the judge.
Yes, sir.
Do you have any questions about the constitutional rights I've explained to you?
Yes, sir.
Do you understand those?
Yes, sir.
Do you have any questions about the plea of guilty, what it means, what will happen if you enter that here today?
Yes, sir.
You understand that?
Yes, sir.
All right, now, Mr. Hofstadter, since you're not sitting next to your attorney, if there's any questions that you would like to ask him about the agreement or what's happened so far, or anything you want to talk to him about before we go any further, I'll put you and him into a breakout room, which means it'll just be the two of you on the screen talking, and no one else will be able to hear you or see you. Do you need to talk with him about anything at this point?
No, sir.
You're
I'm just trying to get in with, I'm just trying to put all this foolishness behind me so I can move on and make a better life. That's all I'm doing.
Okay. Do you have any questions about anything I've explained to you here this afternoon?
Yes, sir.
Then is it your decision to withdraw your not guilty plea, plead guilty to count one according to the plea agreement that we just went over?
Yes, sir.
And as to the charge which alleges that on or about September 10, 2021 in Huntington County, Ohio, you did knowing you were under detention other than supervised release detention or being reckless in that regard, you purposely break or attempt to break the detention or purposely fail to return to detention, either following temporary leave granted for a specific purpose or limited period, or at the time required when serving a sentence in intermittent confinement, and you were being held in connection to a felony in the fourth degree, to wit, failure to register a change of address as a registered sex offender in violation of ORC Section 2950.05 F1, Huntington County Common Police Court, case number 21 CR 0103, violation of Section 2921.34A1 of the Revised Code, charge of escape, third degree felony, carrying possible prison term between 9 and 36 months in the increments provided by law, and a fine of $10,000. How do you plead?
Yes.
All right, thank you. The court finds that on this day in open court, defendant was advised of all his constitutional rights and made a knowing, intelligent, voluntary waiver of the same pursuant to Criminal Rule 11. The plea is accepted, order filed, defense found guilty of count one, as set forth in the indictment. Count two is dismissed. The court finds the defendant is currently serving a prison term from this court. I don't feel there's any reason to order a pre-sentence investigation. So there's also an agreed recommended sentence. So the court will go ahead and proceed with sentencing forthwith. All right, Mr. King, on behalf of the state.
Only was contained in the plea agreement, Your Honor.
Mr. Wagner, anything you'd like to say?
Only we asked the court to follow the recommendation of the state. I met with Donnie once he got back Friday. And I know the court doesn't like escape charges, and we totally understand that. Donnie was utmost gentleman to me, didn't sit here and finagle about this or that. But the only thing he wanted done was this thing done as quick as possible. That was his only request. If he could have done it Friday at 2, he would have, Your Honor. Again, he understands what he did. You're not getting any fight from us, Your Honor.
Mr. Hostetter, anything you'd like to say?
No, sir, I'm just trying to get this book behind us, move on. Trying to be a good person.
All right. Well, it's a judgment before the court then that you be and are hereby sentenced to the Correctional Reception Center in Lorraine, Ohio for a period of 12 months. That sentence is ordered to be served consecutively to the sentence you're currently serving. It was committed while you were awaiting trial or disposition of that case. Also, it's a separate course of conduct, and the court finds that one sentence would not adequately reflect the seriousness of both offenses. The sentence imposed is not disproportionate to the harm it's caused. The court further finds that the defendant's criminal history also warrants this type of sentence to protect the public. According to the sheriff, you were arrested on this charge on the 27th of January. Actually, you were just brought back on the 27th because you were indicted while you were already in prison for them. So you have the 5 days you're in jail now will be applied to that sentence. Now, upon completion of your prison term, Mr. Hostetter, it is mandatory that you be put under post-release control supervision for a period of 1 year under the supervision of probation or the parole authority. And they will set forth the terms of your supervision, and if during that period of time they determine that you have failed to comply, they can return you to prison, make you serve an additional period of up to 6 months for any one or more violations. But if you commit a new felony, while you're under post-release control supervision in this case, then in addition to whatever sentence the judge in the new case would impose upon you, that judge could also sentence you in this case for committing that offense. Could sentence you for committing that offense while under supervision in this case to an additional period, in this case 1 year, because it's 1 year whatever time's left, whichever is greater. Since 1 year is the maximum, it would be a 1 year sentence. And that would order that it would have to be served consecutively to the sentence of the new case. Now, you're also ordered to pay the court costs, which judge will grant execution's order. If you fail to do that, then the court clerk will collect that through various means, including levy on bank accounts, wages, earnings, other assets that you may have. If that doesn't collect it, then once you leave your prison term, not while you're in prison, but once you get out of prison, the court can order you to do community service in this county and give you credit for each hour you work in an hourly rate set by the court. Each hour you work would reduce your judgment by that amount to pay. All right, is there anything further to counsel?
No, Your Honor.
All right, then you're remanded back to custody and be conveyed back. Thank you, Mr. Officer.
Thank you, sir.
All right, the Cody Burke next, officer.
Okay.
Okay, are you Cody Burke?
Butler.
Yes, sir.
Butler.
Yes, sir.
Or Butler, I'm sorry.
Yes, sir.
Looking out the wrong field, my glasses. All right, this case number 21 CR 204, State of Ohio versus Cody Butler. Mr. Butler is appearing by Zoom from the jail. His attorney, Jake Wagner, is present by Zoom, and Assistant Prosecutor King, representing the state's present. Defendant's charged with malicious assault and receiving stolen property. And let's see, I believe this is a final pre-trial. We have a trial set next Monday.
Effectively,
That's
this is the
correct.
first,
Pardon me?
That's correct, Your Honor.
I thought it was I didn't know there was a first and a second, or a second on both, Your Honor.
Oh, is there a second charge?
Was there a second, Adam?
There's another case, but that case is not set for today. But it
Okay.
also was set for trial on Monday.
All right, well, where do we stand then, gentlemen? Tell me what's going on.
Well, I think I've been out, and Mr. Butler and I have spoken. As far as the state, I believe they did, I know they proposed, Cody and I spoke about that. I did send Annika and Adam a late email today on me, not them. I think we'll have this case resolved, Your Honor. We're just fine-tuning a number. I didn't know it was this quick, Your Honor. I take responsibility for that. I didn't know it was set Monday.
Well, he was arraigned right after New Year's, but I think he was charged on December the 1st. So there's 30 days in and 31 in January. So actually we have until the 28th to try him. And probably a little further than that because of a pleadings have been filed. Now, on the other case, I don't have that in front of me. Where do we stand on that one, in terms of, speedy trial?
It's after this one, correct, Adam?
Yeah, well, no, the other case, 21 CR 187, he was indicted on December 7th. It was a bind over, but I don't believe he was in custody.
Well, I don't have that on the docket, so I can't speak to that.
I'm not sure right now off the top of my head.
All right, well, Mr. Wagner, do you wish to continue this case and waive speedy trial so we can reset this out a couple weeks? I see
Yes.
Mr. Butler shaking his head. He's
Tony, is
okay with
that
that.
fine?
Yeah, that's fine.
All right.
Yeah, I'm cool with that.
You okay? You understand that if we agree to this continuance, we'll postpone. I mean, I think your trial's set within the 90 days anyway, and plus, if you weren't being held on that case alone, it wouldn't count three for one anyway, but,
Yeah.
I can push this back a couple, 3 weeks if you're in agreement with that, Mr. Butler.
Yeah, I'm fine with that, bro. I just had surgery on kidney stone. I'm like in agony, so yeah, I'm cool with that.
Oh, well, that's not fun. All right. Well, then the court will, grant continuance of both cases, What's the other case, Mr. King?
The case number is 21 CR 187.
And what is the charge in that case?
Trespassing and habitation, fourth degree felony.
All right. And are these cases related at all?
No, Your Honor.
Okay. So we'd actually have to have separate trial dates then.
Yes, sir.
All right. Well, we'll set a pre-trial out about, let's see, February 16 at 1 p.m. And we'll set trial date on the first case. That was the first one indicted, wasn't it?
Yes, Your Honor.
All right, we'll set it for we'll set it for March the 7th at 8. And 21 CR 194 we'll set for March the 8th at 8.
Do you mean
Check that
21 CR 204?
204.
204, I'm sorry. Yeah, 204. All right. Your attorney will be in touch with you, Mr. Butler, and we'll see you on the 16th then.
Thank you, sir.
Thank you. All right, Mr. King, we have, I think, Mr. Barry's attorney and also the health department case. Those folks are here, so if you want to come on over.
Yes, sir.
Thank you. All right, are you Mrs. Stapleton? All right, if you want to have a seat up here. As soon as the assistant prosecutor gets here, we'll go on the record.
On record.
Case number 21CB165, Highland County General Health District versus Carlos Stapleton and Evelyn Stapleton, and other lieutenants, 11370 County Road. The plaintiff is represented by Assistant Prosecutor King, and for the record, you are Evelyn Stapleton. Okay. All right, this is a hearing on the default judgment motion filed by the plaintiff. The plaintiff filed an action on September 14th, 2021, for injunctive relief to bar the accumulation of solid waste materials on the premises of 11370 County Road, Greenville, Ohio, which is located in Highland County, alleging that it was in violation of 3734.01, 02, 73, Ohio Revised Code, as well as regulations and rules of Highland County General Health District, and also constituted a nuisance. Record reflect that the defendants were served. No answer has been filed, and that's what's meant by default misstatement. And what happens is when someone sues you and you get your paperwork, if you don't file a written response with the clerk of courts within 28 days, then the plaintiff is entitled to file for a default judgment and ask for the relief that was set forth in the complaint. So what I do is always set these things for hearing so I can give the owners a chance to appear in the court to discuss how long it's going to take to get them to reply, because since you haven't answered, you're basically admitted that what they're saying is accurate legally, they're entitled to judgment. Now, I'll ask the plaintiff, has there been any change in circumstances since the filing of this action?
No, Your Honor, there's been slight progress. There has been some cleaned up. I'm looking at pictures that were taken of the property on Thursday, and there's a significant amount of trash that's on the property, so it needs to be removed.
Okay. So, Mrs. Stapleton, under the law, since they are entitled to call, I issue a judgment against you and Mr. Stapleton, telling you you've got to clean the property up. And I want to give you a reasonable amount of time, and I understand the weather's bad right now. But have you done anything to try to make arrangements to get the place cleaned up so you can get this behind you?
I have pictures of the way it was before and now how it is. I mean, we have rented a dumpster, as a matter of fact, 2 dumpsters, filled them up, taken them off of the property, and it seems like each time we do what they ask, then they come back with something else that needs to be taken care of.
Well, what they ask for is for the property totally cleaned up. And all the debris and all the things that constitute solid waste have to be removed. That's what they're asking for. If you make some progress, that's good. My question is, how long do you feel that you would need to get that finished?
At least another 6 months.
Well, I can't give you that long. You're going to have to do it. Look, I'll give you 60 days. I was hoping you might say 30 or 45. Well, I'll tell you what, I'll give you 90 days. But we're not going to let this go on forever.
Right, I realize that.
And if you can't do it yourself, then you need to look into hiring somebody to do it, or family people to help or something, but it's going to have to be done because.
But see,
we're
I
going to get into
don't
summer
know
months.
exactly what they are considering solid waste. This is a farm, and there is metal, which is legal to have for this business, for this farm. And the only thing that I know that they want removed now are some plastic boxes, which I don't feel are waste. I mean, my son purchased those boxes, and he said he had a use for those. But now he's passed, and we have no idea what he was going to use those for. So, I don't consider that waste. And yes, they did find some tires, which we're going to have removed. But I don't know what else that they consider waste.
Okay, so you want to answer that, Mr. King?
So
Because I'll tell you the pictures that are attached to the complaint. Might as well not attach them. You need to get a color printer so that we can, when you look at them, because your
You can't
black and
see.
white copies
Can't see anything.
You don't.
Can't see anything, they're just smudges.
Well, if you were to go to this property, there are hundreds, over 100, probably closer to 500 boxes just stacked and stacked. There are blue film canisters that have film in them just piled up, in the brush, hundreds of those. I mean, it's just.
Can you give me the color pictures that you filed with the report so I can take a look at
Yes,
them? That would be helpful. And like I said, you might want to invest in, just print out color pictures of the future attached.
Yeah, our pictures are black and white too, so it was very difficult for me to see.
Oh, I couldn't see anything in them other than
Right.
shadows. That's why I was asking. All right. Now this is, I see, it looks like a bunch of, it's like a concrete piling with metal fence posts in them. That's definitely trash. Tires, I see the tires. There's some snow on the ground, so I can't see exactly what that is, but it's obscuring what appears to be some kind of broken clay or something containers. I see some blue metal, which are out below. They're not stacked in a manner that would appear to be business-like. They're amongst, it's like a big trash pile and by some trees. There's a tire pile in one of them. These blue containers, I don't know if they're the same ones you're talking about, but they're not containers. They look like they're a pile or almost like a, I don't know what's the word you want to use, stack stuff on it.
Those blue, are you talking about the blue? Those are apparently film canisters that have film inside of it.
Really?
Yes.
Oh,
Yes.
one that's tires on?
I'm
Looks
not,
to me like
I'm not sure which, there's a mass of blue.
yeah, this one here.
You haven't got to it yet.
Yeah.
You're not looking
No,
at
that's just, and I can't think of what it is. On the stuff, you usually would. You put stuff on it. Pallets, thank you. Blue pallets, they look like plastic pallets. Then I see some canister or some metal boxes, and one looks like there's a couple of lids off of them. See some more trash in there. Okay. If you think it's not trash, then I would think you would store it in a manner that's not trashy looking, because, if it was something that were being held for a business purpose or something, I would think you'd have these things stored inside out of the weather. I can see a couple of them look to be rusted through, have gashes in them. They're just piled up. There's an old pallet, a wood pallet, a whole bunch of brush grown up all over. That's trash. And here's a really good picture of them. That's what they're referring to. That's solid waste. That's not a business inventory. Okay. Yeah. I think it's pretty evident what the trash is. And if you say there's metal there, I don't see any metal inventory per se. Well, yeah, here I do. It's all just out there behind this mobile home. Tires all mixed among it and everything. That's just garbage. It's not something that you're keeping for business. Now, if you want to get it in a business manner, or get it stacked up, put on wood or something, and maintain it in a business-like manner, then that certainly would be appropriate. So what I'm going to ask is for the prosecutor to get some copies of these, the health department, whoever printed these out, get these to you. And so I'm going to go ahead and put, you got another copy of these? I want to substitute. Some of these are just taken today, right?
I don't need those.
All right, so basically, if you can get more copies from this Stapleton, but I think, if you're going to argue that something, you don't have to clean something up because you're keeping it for business purpose, then let's put it in a business purpose organization, which would be stacked and inventory and out of the weather, because this is just trash. It's just laying. You can see it's been there for a long time. There's brush growing up all over. So, it's not illegal to have things like that, sure, but if you're just accumulating trash and letting the neighborhood don't like it, you get vermin in there, and it's unsightly, and it becomes a nuisance, and that's what it is. So I'm going to give you 90 days. Grant judgment in favor of the plaintiff. I'll give you 90 days to comply. Now that doesn't mean that on day 89 you bring a dumpster out and you start having somebody haul stuff out.
No, I haven't.
You need to start making immediate steps, and I'm sure they'll come down and take a look at it from time to time. And, you know, if you do want to keep some of this stuff and get it organized, whatever, talk to them about how they feel it will be stored in a manner that's not going to be considered solid waste. But right now, the stuff I'm looking at there, it's just trash. That's all it is. You know, and it might be, you know, I know they will say one person's trash is another person's treasure, but it's not being held in a manner that offers it for sale. You know, I don't think the pickers are going to come down from there and take a look at that stuff. That's it's not even something they do. So you got 90 days to do it, and you're also working days court calls. Now, if you fail to comply with the court order in Stapleton, you know, they could ask for you to be held in contempt, and that could end up with a fine and even a jail sentence for failure to comply. So, you know, they don't want to see that. I don't want to see it. They just want you to get it cleaned up. So, if you got questions, instead of coming to court and asking the judge, communicate with them. And again, what you just told me until I see some good pictures, now when I see it, you know, your statements to me, I don't understand how you couldn't understand that this is a solid waste. All right, that'd be the order of the court.
Yes, sir. I have one more thing. I have 3 options at this point on getting rid of those boxes, so, and it's not the dumpster. So I'm going to look into all 3 of these options.
As long as you get rid of them in a lawful manner, we don't care. I mean, that's up to you. We're not telling you how to do it, but you just have to see it's removed and stored in a proper manner. Don't want you to pick this all up and haul it to another property and get rid of it in a, you know, proper manner. Or, you know, again, if somebody thinks it's materials that could be used in the business, then they will, you know, get them organized and protected in such a way that it's clearly their inventory or materials for a business and not just junk. Okay? That's right. Thank you. All right, State of Ohio versus Jerry Berry, I believe.
Good afternoon. Will we have a chance to just meet with you briefly in chambers prior to sentencing?
Is there a problem?
There's not a problem. There's something I want to bring to your attention off the record.
All right. Take your questions.
Thank you very much.
Council, walk out, please.
Excuse me.
It's like I was invisible, wasn't I?
Snowballs.
I forgot something.
Cody, courtroom, they do, so we're looking at. So before, we've never had that happen. I got a file full of those forms. Make sure your phone's off. Recording the pictures. Okay.
All right, case number 21, CR 194, State of Ohio versus Jerry Wayneberry Jr. Present on behalf of the state is Assistant Prosecutor King. Present on behalf of the defendant is Attorney Kilburn. You are Jerry Wayneberry Jr.
Yes.
Mr. Berry has entered pleas of guilty to 2 counts in a bill of information. Both are first-degree felonies. I believe sexual battery. I think the pleas are.
Yes, Your Honor.
Okay. Here's the plea agreement. Yeah, the bill of information doesn't say. 297385 sexual battery. All right. We entered pleas of guilty to those 2 charges on the 27th of December, and the matter was set for sentencing today. Now, before we do that, though, the court's required to designate the defendant as a Tier 3 sex offender. Do you have that? Yes, here it is, registration form. Thank you. All right, Mr. Berry, the 2 charges of sexual battery require a designation under the law of a person who commits those offenses as a Tier 3 sex offender, child victim offender register. That means that you'll be required to register and comply with the conditions I'm going to explain to you here for your license. You'll be required to register in person with the sheriff of the county in which you establish a residency within 3 days of going into that county. Or if you're going to be temporarily domiciled or staying there for more than 3 days. You're also required to register in person with the sheriff of the county in which you might establish a place of education immediately upon coming into the county. So if you end up going to any kind of educational programming, whether it be college or vocational school, training school, whatever, you're required to register immediately when you go into that county. If you are employed in another county for more than 3 days in a row, or 14 days in any one calendar year, then you're required to register with the sheriff of that county. So potentially you could be required to register in 3 places: where you're living, where you're employed, and where you're going to a place of education. And for purposes of this law, employment includes volunteer work, community service also. Now, in the event that you were to go into another state, either to live, work, or for educational purposes, you must also register then in the counties of those states with the public official that would be designated to have that responsibility under that state's law. Now, if you're going to be absent for more than 7 days from your county of residence, then you're required to, it's actually 7 days or more, then you're required to notify the sheriff where you will be staying and how long you expect to be there. So like if you're on vacation, visit family, going to go to the hospital, or end up if you have some kind of surgical procedure, have to be in a rehab or nursing care for a while, you have to notify him of that, he or she. Now, you'll be required to verify the information with these locations every 90 days. And you can register, or you can go in person. It must be in person. You can't do it by mail or email or phone. You have to go in person to that sheriff's office no earlier than 10 days before your verification date. So you have a window of every 80 to 90 days to verify your information. Now, if you change your residence, your place of employment, or your place of education, then you're required to provide written notice of that change to the sheriff of the counties in which you're registered. And if it's where you're living, you are going to change your residence or your place of employment, of education, you're required to notify them about at least 20 days before any change. Now, for employment, you can do it up to 3 days after you change, because again, you can stay in one county or work in one county or location 3 days before you have to, 3 days in a row before you have to register in that county. Now, if for any time you should not have a fixed address, you'll be required to notify the sheriff with a detailed description of place or places you intend to stay. Then not later than the end of the first business day immediately following the day you do obtain a fixed address, you must register with the sheriff that fixed address. You're required to provide written notice to the registering sheriff's offices within 3 days of any change in your vehicle information, email addresses, internet identifiers, telephone numbers registered to or used by you to the sheriff of those counties in which you have most recently registered. Under federal law, you're required to report any international travel that you may have if you have a passport to your registering authority 21 days before traveling. Failure to do so could subject you to a criminal prosecution under both federal and state law. Now, since your address is 116.5 East Walnut Street, your county of registration for residency purposes is Highland County, and that is at 130 Homestead Drive in Hillsborough. All right. Mr. Strange, if we did that. There's a place for you to sign your return or sign that acknowledges that I've explained the requirements of this to you, Mr. Berry. All right. Now, the court now will proceed with sentencing. Anything from the state regarding the matter of sentencing?
Only what's contained in the plea agreement, Your Honor.
And there's no victim impact statement or anything representing the victim that wishes to address it.
That's correct, Your Honor. The state has consulted with the victim mother. She's approved this agreement.
All right, Mr. Gilman.
Thank you, Judge. Just briefly, you'd ask the court follow.
Stand and address the court, please.
Thank you, Judge. We'd ask the court follow the recommendation, the sentencing recommendation of the parties. Your Honor, Mr. Berry is 51 years old. He has no prior criminal record to speak of. He is from Hillsborough. He works full time. He was the manager of Precision Garage Door Services. He did that in Tennessee when he lived down there. He's lived up here for a few years now. Started a family business, garage, my understanding, a garage door repair and installation service company. His family business, his sons help him out with that. Again, Judge, no prior record. Would like to, just so the court is aware, to put this in context. Judge, he did, experience some childhood trauma that significantly, I believe, impacted him, that he carried with him through his adult years, and he's experienced traumas as an adult. His father passed away in the spring of 2020, unfortunately by way of suicide. He's been through a lot, Judge, and again, that does not excuse or justify his actions, but Your Honor, he has been through a lot, and Your Honor, he has accepted responsibility in open court. I know he's embarrassed and ashamed for his actions. I know in my discussions with him, he's extremely remorseful, and I think that remorse is sincere. Your Honor, as a result of this plea, he obviously will be a convicted felon, convicted of an offense that is not sealable from his record. will remain with him for the rest of his life, as well as the nature of that, which is a sex offense. He's going to have to register as a sex offender for the rest of his life. He will have to serve time in prison. He understands that. But, Your Honor, we're asking that the court follow the recommendations. We believe that that is the appropriate resolution at this time. Thank you, Judge.
If you can refresh my memory, Mr. King, the age of this victim?
She's 14 years old, Your Honor. However, I would also note that it's my understanding there is potentially slight development of this.
I'm sorry, there was what?
She's somewhat developmentally delayed. I don't know the extent of it. I'm aware.
14 at the time of these
She's
offenses?
14 at the time of these offenses, yes.
Okay. All right, Mr. Berry, is there anything you would like to say?
Judge, I want to apologize to my family, the courts, the public, for my actions. I've embarrassed a lot of my family. I've hurt financially, or my company, my children, the stepchildren. My actions was just not proper. And I'm very remorseful for what's happened. It's something that I've got to live with the rest of my life.
All right. Well, it's a judgment in order of the court that the plea agreement will be followed because Mr. Berry has taken responsibility. These are extremely serious crimes, and taking advantage of the relationship that you had facilitated that crime. I know this wasn't agreed case. Your attorney, you got an attorney early, and he worked with the state to come up with a resolution that was agreeable to both parties. My hunch is that had you been indicted, it would have been for much more serious offenses. But nonetheless, you will have to come before the court and admit these. Now, quite honestly, most sex offenders I see have had themselves been victimized as children in one way or another. It could be physical, it could be sexual, it could be mental, and that's deplorable. But it's certainly not a justification or excuse. But it certainly would indicate that you have issues that need to be dealt with, and you haven't dealt with them. And so that is concerning the court for your future in terms of what might happen. One of the reasons we require lifetime sex offender registration is because, quite frankly and sadly, it's hard for sex offenders to be treated successfully. And so there's a very high risk of recidivism. And so that is a way of keeping the people in the vicinity where you live notified that you're there. So people that have children that could be victims or concerned to be victims are aware. And so, there are going to be some ramifications for that. But what I'm saying is that I would hope that once you complete your prison term, that you take upon yourself to at least try to get some help. And I think that, in my understanding, and I've been in this business now for almost 46 years, is that the best thing can be done is to manage situations to avoid being put in a position where you might reoffend, or even, like I said, going into sex offender treatment even after you get out of prison. So I would hope that would be something that you would think long and hard about. It's a judgment of the court, Mr. Gray, that you be and are hereby sentenced to the Correctional Reception Center at Warren, Ohio on counts 1 and 2 to separate terms in each count of 30 months. It's further ordered that those sentences be served consecutively to each other for 60 months. The court finds that consecutive sentences are appropriate in this case. First of all, there was a stipulated recommendation to the court for that sentence, which the court had approved. Secondly, they're limited in course of conduct involving multiple violations, and the court feels that one sentence would not adequately reflect the seriousness of the offense, and the sentence that's being imposed is not disproportionate to the harm caused. It's a middle of the road sentence, and further, that it's necessary for the protection of the court. According to the sheriff, you were arrested on the 11th of November, released on the 3rd of December of last year. Is that correct?
It works.
Yes, that'd be 23 days if you had time for it. Now, upon completion of this sentence, as it indicated, you'll have to report to the sheriff when you get out of prison in 3 days to register where you're living. And you'll also, at that time, be placed under post-release control supervision for a mandatory period of 5 years. That'll be under the supervision of the adult parole. And they'll set the terms, conditions. And if they determine during the period that you're being supervised of 5 full years, that you have not complied, then they can return you to prison even though you serve the entire term set by the court, for an additional period up to 9 months for any one violation, but there is a cap or limit of half of whatever prison term is imposed. And so in that case, that'd be 30 months for multiple violations. However, if you were to commit a new criminal offense while you're under post-release control supervision, and in this case, then in addition, whatever sentence the judge in that new case would impose, that judge could also sentence you for committing that offense while under post-release control supervision in this case to an additional period of 1 year, whatever time's left on that 5 years of post-release control, whichever is greater. If that occurs, that must be served consecutively to the sentence in the new case. You're also ordered to pay the court cost, which judgment is granted and execution is ordered. And if you fail to make those payments, then the court can collect that through various means, including levy on bank accounts, wages, earnings, or other assets you may have. And if that doesn't collect it, then upon your completion of your prison term, not while you're in prison, but once you get out of prison, then the court could order you to do community service in this county and give you credit for each hour you work in an hourly rate set by the court, and each hour you work would reduce your judgment by that amount until it. All right, is there anything further, Counsel?
No, Your Honor.
All right, you remanded to the custody of the sheriff and for execution sentence, Mr.
Thank you, Judge. Very good, sit back, Deputy Thompson. Sure. Anything?
No,
JD is quarantining himself, I think, because of exposure to his kids.
I think his daughter,
Yeah. So, but his client, Mr. Hill, doesn't have an email. I don't know if you're aware whether they made any arrangements for this to be go Zoom or not.
I have not heard anything about that.
All right, let me get I'll find out. Yeah, about a month ago, it was his son, and then him, or then now there's some.
Right.
What are we gonna do about Mr. Hill? Is he gonna go to JD's office?
I've got an email, I'm going to,
Oh,
supposed to log in.
okay, so I can go back to the Zoom hearing?
Yeah,
Oh, okay.
yes.
All right, looks like it's gonna be Zoom then, Adam.
Okay.
So I said, if he can figure out how to do it. So we'll see.
Office.
Thank you. Yes, sir. Have a good day, Judge.
Yeah, you too, thank you.
He's back. There you go. We'll go over for this right here.
Thank you, Nick.
Yes, sir.
And then at 2:30 will also be the Zoom, and this goes.
Recording in progress. Recording stopped.
Okay, is Hill ready?
No, not yet.
Okay.
There's nobody there yet. Adam.
Oh, that's right, yeah.
So, that was supposed to be 2.
Turn off our This is Hill,
Yeah.
okay. If he's in the office with JD or if he's,
JD, is your client gonna be logging on?
He's supposed to, Your Honor. I had changed of plans and I have to work from home today.
Yeah, I understood that.
Uh,
What is that behind you? Is that a,
I've got, it's a quote I saw from Jim Valvano.
Oh.
It's a big quote, kind of, I don't know.
I think I've seen it before. Yeah,
Says a man should like laugh every day, cry every day.
yeah. He said that when he was making his speech. His voice, all right. Let's go ahead and go on the record.
Hello, Judge.
All right. Case number 22 CR 0004, State of Ohio versus Russell L. Hill. This hearing is being conducted by Zoom, appearing after Attorney Jacob Wagner. His client is on the phone through Mr. Wagner and is participating that way. Assistant Prosecutor King is representing the state. Defendant is charged with weapons of disability, possession of cocaine, aggravated possession of drugs, and forfeiture. This is the first pre-trial. We have a final pre-trial on February 16th and a trial date on March 21st. I see that the state and defense both provided discovery. Is that finish it up as far as the two of you know?
It is from the state, yes, Your Honor.
This time, sir.
All right. Do you anticipate any pre-trial motions, Mr. Wagner?
Not at this point, sir.
All right. And has there been a written plea offer provided?
Yes, Your Honor.
Yes, sir.
All right. Is your client aware of it?
Not at this time, Your Honor. Due to my circumstances today, I've not been able to get with him.
Yeah. Okay. All right. All right. Then is there anything else we need to discuss at this point?
No, Your Honor.
No, sir.
Then we'll be back on record. Mr. Hill hopefully will be able to log in on the next one on February 16. That one will be by Zoom too, I'm sure. So,
Yes, sir.
we'll probably be doing Zoom for the rest of this, for the next month. And then hopefully things are going to
Yes, sir.
start slowing down where we can ease back into in person. So, all right.
Thank you, Your Honor.
Thank you.
Thank you.
All right. See, Ms. Phillips is logging in. I don't know about Ms. Witt. If we can, I'll have Marcia buzz her and maybe she can get on early.
Yeah, 15 minutes early, so.
Yeah. It's 2:16, so she may be in courthouse. She may not be available earlier. Ms. Phillips, we're trying to get a hold of your attorney. It's early. Would you text Danielle, tell her her client's already on and Adam's there, so if she's available, we'll get this done quick. Otherwise, we'll wait till 2:30.
I'm sorry, I just missed what you said. My phone wasn't.
Oh, okay. Your attorney is, you're a little early, and so we're gonna see if we get your attorney. I don't know if she's available or not. Sometimes she's in the courthouse, and I don't know what time she's available, but if she's available early, we'll go ahead and get her, and if not, we'll have to just wait until 2:30. So my assistant's trying to get a hold of her now.
Okay, thank you.
Mm-hmm.
Let me close out the YouTube bit audio.
Recording in progress.
Okay, this is case number 21 CR 198, State of Ohio versus Jennifer Phillips. And you're Jennifer Phillips. You need to unmute there, Ms. Phillips. Okay, you're Jennifer Phillips. Okay. This hearing is being conducted by Zoom's pre-trial. Ms. Phillips' attorney, Danielle Witt, is present, and also Mr. Adam King on behalf of the state assistant prosecutor. Ms. Phelps is charged with possession of cocaine and aggravated possession of methamphetamine, both fifth-degree felonies. This is the first pretrial. Final pretrial is set for February 16th. We have a trial date set for March the 7th. I see that the state did provide discovery of the bill of particulars last week. You received those, Ms. Witt?
I have your.
All right. I don't see your discovery. It'll be due by final pretrial. Do you anticipate any pretrial motions?
Your Honor, I actually haven't been able to speak with Ms. Phillips yet, but I believe that if I can just ask her a quick question.
Yeah, go ahead.
Are you married to Christopher Nichols, or were you a victim in this case? Yes? Okay. Your Honor, I represented Christopher Nichols, who Ms. Phillips is a victim in a case of his in municipal court for domestic violence.
Oh, okay. How recent was that?
I'm still representing him.
Oh, it's current. All right.
Yes.
All right. Well, I did not know that. All right. So your final motion was well taken.
Yes, I will today.
All right. What's going on, Ms. Phillips, is that, and I've said I don't have knowledge of all the cases that different attorneys have when we make the appointments. And so since she's representing Mr. Nichols and you're a victim in that, that's a direct conflict of interest for her to be able to represent you. And so I'm going to have to allow her to withdraw. So I'll be appointing another attorney for you. And give me your phone number if you would, so I can give it to the new attorney.
937-779-9988.
All right. Okay. And you're still at the same address?
Yes, sir.
Okay, all right. Well, I'll talk to my assistant as soon as we get done here and probably try to find somebody here by the end of the day, if not first thing tomorrow morning, so that they can get in touch with you before your next hearing on the 16th. That hearing will also be a Zoom hearing, so we'll go ahead and send it to the same place. If you should change emails, email addresses or anything before then, make sure you contact the court and let us know, as well as your attorney, whoever that may be. All right? Thank you.
Thank you.